Welcome to this, the next episode in the Dear Street Barristers podcast, The Advocate's Lounge. My name is Jonathan Godfrey and I'm a specialist clinical negligence and personal injury barrister. Today I'm actually going to be speaking to you about the expert agenda and discussion in clinical negligence. In undertaking this, I'm going to be speaking to you about the principles involved and also the case law itself. In relation to this, I have to say at the outset that I wrote an article recently for the AVMA clinical newsletter. And in that newsletter, I set out that the most important thing in any clinical negligence case is the expert medical evidence itself. That may seem obvious, and it's no so more obvious than in this extent when we're considering the expert agenda and the expert discussion. So having said all of that, what is the genesis of this? What is it we need to look at in relation to the expert agenda and also the expert discussion? Well, in that regard, can I take you to the CPR 35.12? The CPR itself sets out at CPR 35.12.1 that the court may at any stage direct a discussion between experts in relation to try and identify and discuss certain issues. Those issues are to try and reach an agreed opinion on certain issues, and if they're unable to do so, then set out those matters upon which they disagree with a summary of the reasons for their disagreement. Now, in relation to this, most of you will be aware of the fact that the court actually does provide directions in relation to the expert meeting. But you may also find that rather recently, parties are looking pre-issue to try and adapt the directions to deal with expert meetings at that stage. Turning then to how we deal with this practically, firstly, we have to look at how it's dealt with in terms of how the parties put questions to the experts, and that is dealt with by way of the expert agenda. The experts are to be provided by the parties with an agenda to aid in their discussion. Those questions should, as per the CPR, be aimed at narrowing the issues involved. You will note that I refer to agenda in the singular. We'll come to that later in the discussion. But the agenda is, as I say, to be agreed as between the parties. Following the agenda being provided to the experts, following their discussion, should then provide a joint statement in which they set out their areas of agreement and disagreement with a summary of that disagreement. It sounds simple, it should be, but as always, it's not. Now, in relation to that, and from the practical purposes of what we're considering, can I take you first of all to a case which is in itself a clinical negligence case and involved the question of the agendas themselves. And this case is the case of Saunders and Central Manchester University Hospitals NHS Foundation Trust, which is reported 2018 EWHC 343 in the Queen Bench Division as it was then. This is a case that was decided by Mrs. Justice Yip. Mrs. Justice Yip was a serious and experienced clinical negligence and personal injury practitioner, and now is basically the mainstay of what is now the King's Bench Division for clinical negligence cases. This case unfortunately involved two agendas, and it produced what was a 60-page joint statement from the experts. Mrs. Justice Yip, in commenting upon the approach that had been taken by the parties, said quite fundamentally that she thought it did nothing to narrow the issues. And she went on to say this, and if I can quote, that the parties should adopt a common sense and collaborative approach rather than allowing this stage of the litigation to become a battleground. Frankly, the approach to the joint statement in this case achieved nothing of value. She went on to say that the statement itself confused rather than assisted, and she made the very pertinent point, and a point that we should all be looking at as lawyers, that sometimes less is more as far as the agenda is concerned. Having dealt with the case of Saunders, you think that the pronouncements made by Mrs. Justice Yip may have yielded the fruit that she was asking for. In truth, that wasn't the case. Almost immediately afterwards, she looked at the case of Welsh and Walsall Healthcare NHS Trust, which was reported at 2018 EWHC 1917 Queen's Bench Division. Again, in this case, two agendas were provided to the court, two very lengthy agendas. And in relation to this case, Mrs. Justice Yip made the pronouncements that she had done in the previous case of Saunders. She went on to also say that there ought to be some give and take. And she went on to say if this worrying trend continued, then it could result in cost sanctions. It would then seem that all matters had been resolved, but again, no. We now turn to the third case of Adorno and Colvin, which is reported at 2021 EWHC 2293 Queen's Bench Division. This was a matter that came before Master Cook, and in relation to this, again, you've guessed it, there were two agendas that were produced for the court. There were 41 questions, of which the Master went on to say only two were of any assistance. And he went on to also describe that the agendas were in themselves what he described as being over-lawyered. In relation to the joint statement, he went on to say this, that it is for the benefit of the court and should not be seen to be a proving ground for the parties' respective cases. So looking at these cases, where does it leave us? Well, we can possibly say this. Firstly, as I've already alluded to, you should be looking at one simple agenda. Secondly, in relation to that, whilst you may wish to stand your ground, be prepared to compromise. It's not weak, it's about being collaborative. So look at that and what's been said by the court in relation to the other cases. And lastly, also consider to stick to the issues. The issues can be narrowed very succinctly. Now, I've actually lectured two experts in relation to their duties as medical experts under CPR Part 35. And one of the matters that's come out in relation to those lectures that I've undertaken is very much the case that they believe lawyers deal with peripheral issues. They see them as pedantic. Try, if you can, not to move in that direction. So we've dealt with that, and now we have to turn to the discussion itself. I term it discussion because that's what's said in CPR 35. But generally and colloquially, we talk about the expert meeting. The expert meeting is something which, of course, as lawyers, we look at and consider aghast. It's almost as though the sword of Damocles is above us, because in relation to it, we have left the experts very much at their own direction. Now, it may well be in relation to this that it all goes well, and if that is the case, then your experts can be lauded with the trumpets upon returning to their consultation rooms. If they don't and they concede, then the problem, of course, in relation to that is all the work that you've done seemingly in a case that you thought had good grounds of succeeding falls by the wayside. So in relation to the discussion itself, what should we consider? Well, in relation to this, the expert discussion should be, and I describe it at the outset, as sacrosanct. Leave it to the experts to consider. There should be no discussion of any substantive matters, of drafts of the joint statement, and anything in relation to the lawyers. You, as lawyers, should stay out of the proceedings together. Now, in relation to this, there have been some cases which have actually looked at the question of the involvement of lawyers in relation to the joint discussion itself. The first of those cases is not a clinical negligence case, but one that we need to consider. It's the case of BDW Trading Limited and Integral Geotechnique Wales Limited, 2018 EWHC 1915, and that was in the construction court. Quite a mouthful in itself. Now, in relation to that case, His Honour Judge Stevens considered matters, and in relation to this, there had been a draft sent by the expert to their lawyers, and he said this: the expert should not ask the solicitors for their general comments or suggestions on the content of the draft general statement, and the solicitors should not make any comments or suggestions save to both experts in the very limited circumstances. So we can see in relation to this, the court was quite clear, and in relation to this matters that basically lawyers should stay out of the framework. Again, one would consider that that would be enough for the lawyers to understand. Unfortunately, this came to a head once again in the very recent case of Patricia Andrews and others against Chronospan Limited, which is reported at 2022 EWHC 479. In relation to this, the matters that actually prevailed were even more serious than in the previous case. Here, the parties admitted that it was established there was frequent communication between the claimant's solicitor and their expert during the period of the joint expert discussions. And this included not only telephone calls, but also emails and copies of the working drafts exchanging hands also. It came before the court, and the claimant's solicitors acknowledged that their conduct was inappropriate and accepted that they had made at least 16 comments relating to the advice and suggestions as to the content of the statements themselves. The matter was considered by Senior Master Fontaine, who considered that the conduct was what can only be described a serious transgression of the CPR 35 practice direction. And in relation to this, the court considered matters and decided that the expert involved should not continue in relation to the case, but did allow for another expert to be substituted in their place, but made the consequent cost sanction. So one can see in relation to this, as a lawyer with the dealing of the case, there are cost consequences that can follow, and you need to be aware of those. Now, in relation to this, the position that then followed is that the Senior Master concluded that in relation to these matters, the important thing to consider was that cardinal principle upon which we should all be aware when undertaking clinical negligence cases, that it is the integrity of the expert and the integrity of the discussion process is preserved. So in relation to this, it would seem apparent from this particular case that everything was set out, and as lawyers, we were to know to keep away. That would have seemed to have been the case, but very recently, in relation to the case of Glover and another versus Fluid Structural Engineers and Technical Designers Limited and others, reported at 2024 EWHC 1257, this matter raised its head again. Now, in relation to this, the same point arose, namely the solicitors got involved in the draft statement. In relation to this, it came before the court, and the party on the other side sought to actually exclude evidence in its totality. The court considered this and again decided that whilst that particular expert couldn't continue, it was a matter whereby they could actually substitute in a further expert, and again the position would be dealt with by one of costs. In relation to this, the solicitors themselves really did quite put their hands up, and they said that they'd been involved not by any point on their behalf to seek an advantage, but simply because it was misguided and not deliberate. And they said in the evidence before the court that the non-compliance arose through what could be termed a failure to understand the applicable rules and guidance. So that's where we find ourselves in relation to the case law about the discussion itself. And I think we can all see in relation to that that it's quite clear. As solicitors, please keep out of the process of the expert discussion. If I can refer to a particular analogy by way to the criminal law, in relation to that, the process in relation to a jury is sacrosanct. Almost look at that in relation to the question of the expert discussion. Don't get involved. It's as simple as that. Once the experts are meeting and they're discussing, leave them to their own devices. And once again, I simply want to finish in relation to this. The principle that has to follow in relation to all of these cases is very much that expert evidence has to be seen to be independent and objective. I hope that this has actually dealt with a number of issues in relation to matters pertaining to the expert agenda and also to the expert discussion stroke meeting itself. It can seem to be a very simple process, but as I've gone through in relation to the case law, it can in itself prove practically difficult. Thank you very much for listening to me. I hope it's been of some use to you as far as today is concerned. If you wish to actually obtain any copies of any slides in relation to my talk today, please contact me at j.godfrey@deerstreet.co.uk, or alternatively, simply give me a telephone call. If you wish to speak to the clerks and obtain copies of those slides or anything else, please feel free to contact the civil clerks at Deer Street Chambers. Thank you.